Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk. And first on the docket, Joshua Brown, the witness in the Amber Guyger case. A key witness was found shot on Friday night. Next on the docket, the Supreme Court begins its fall term. Did you know that October 5th was Wrongful Conviction Day? And an interesting case out of North Carolina. A wife cheats on her husband sues the other man, and gets a $750,000 award in his favor. Allison Todd is not going to get the Mother of the Year award. However, she has catapulted herself to the winner's circle of the Dumb Criminal of the Week, and it's only Monday. So let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk. Thank you for tuning into our channel. We do appreciate it. If you like the channel, please subscribe. If you like the video, hit that thumbs up. And always leave a comment. We want to know what you think. Some of the best cases that we've been able to talk about have come from information from the subscribers. We appreciate it. First on the docket, a key witness in the Botham Jean case. Now, first, you may have heard that very French pronunciation. Where did we get that from? We went back to the trial and we listened to Allison Jean pronounce how she pronounced her last name so that I could try to make sure I got it correctly.
Please state your name and spell your first and last name for the court reporter.
Allison Jean.
If there's one thing I've always done is ask my clients when the court called their name and they said, how do you pronounce it? Or the court mispronounced it. I always said, no. You've got one name in life. Let's make sure they get it correct. Okay? So, tragedy once again in Dallas. Joshua Brown, the young man who lived across the hall from Botham Jean, who looked at his peephole, saw Amber Guyger walking back and forth on the phone, thought that he heard some sort of interaction that sounded like they were surprised to see one another. He was found Friday night about 10:30 p.m. in the parking garage associated with his apartment. Now, apparently, Mr. Brown had previously been shot about a year prior to the Amber Guyger incident on a completely unrelated matter. And apparently he was apprehensive about coming forward and testifying. He did testify, and now this happened. Now, I hope, okay, this is a tragedy. Mr. Brown should not be dead. But I hope that this is not related to his testimony in the Botham Jean trial. And the reason would be because if somebody were to do that, to attack and retaliate against a witness, that is not an attack just on Mr. Brown, his family, the people in the city of Dallas. That is an attack on all of us and the entire judicial system as it exists. One of the things that we need to have in our system is to make sure that witnesses can come forward and they're not going to have to be in fear of some sort of retaliation for their testimony. There is no credible evidence at this point, and we are not going to speculate about anything at this point. My understanding is there are no suspects by the time that we are airing this, and if that changes, we'll let you know the facts, but we're not going to speculate. But hopefully the police have some leads. He seemed like a brave young man, and it's unfortunate that he would have to have these tragic consequences. The United States Supreme Court began their term today, October 7th, and on the first day, there were several interesting cases related to the world of criminal law. The first is going to be the issue of discretionary life without parole for juveniles. And in this particular case, it was the D.C. sniper case, Mr. Malvo, who was a juvenile at the time. Malvo was a minor during the 2002 rampage and is serving a life without parole. And he wants a new sentencing hearing in light of the Supreme Court precedent that has been more lenient toward those who committed crimes when they were younger and their brains were not fully developed. And so the issue is he entitled to a new hearing with life without parole because he was a juvenile, or because it was a discretionary life without parole, he shouldn't be. So I think they're going to lean in favor of the minor in this particular case. I don't believe that Mr. Malvo is going anywhere. Another interesting case is going to be the case of Calor v. Kansas. And in that particular case, Mr. Calor had done some very terrible things that resulted in the death of his family, and he wanted to put on a not guilty by reason of insanity defense. Well, the Kansas legislature had passed a law basically stating that you cannot use a defense of insanity. Obviously, Mr. Calor lost. He lost again and through the appellate process, and he's at his last stop at the United States Supreme Court. And I'm not sure that this law makes much sense. It goes to the mental state, the mental element of any offense. Going back to law school days, the mens reas and actus reas that people have to have. You have to have that guilty mind, okay? And when you're insane, you don't really differentiate between what's good and what's bad, and the voice has told you. And, some people completely malinger, make the whole thing up. Some people are truly mentally ill. My experience has been the ones that are malingering say, ooh, send me to the state hospital for evaluation. The ones that are truly crazy in the sense of mentally unstable, mentally ill, they're the ones that think they are completely fine and don't want to go to the hospital because they're okay. But I think the greatest misconception that most people have, if someone is found not guilty by a reason of insanity, it does not mean that they are free, okay? All that means is it says you were guilty, you were insane at the time of the offense, but guess what? We're going to send you usually to the mental hospital for a term of incarceration, usually the length of the sentence that they could have received had they just been convicted. So if you commit murder but you're not guilty by reason of insanity, you could wind up spending the rest of your life in the hospital. Classic example of this. Remember, John Hinckley Jr., he's the one that shot President Reagan. His defense was not guilty because of mental impairment. He was crazy. They've restored him back to it. And, now he gets day passes and things like that. But we're talking 30 plus years later, he's still in the hospital and probably will be for a long, long time. So huge misconception. I think the state of Kansas is going to lose in this particular case. There will be a lot of interesting cases coming up this term on the Supreme Court. And we've been thinking about it, and let us know. We have another channel we were thinking about starting, which was voir dire, kind of the way this started, which means it's a French word to means speak the truth. And we thought that would be maybe geared toward maybe a little longer type of discussion about particular cases with other attorneys. So let us know what you may think about that. Next on the docket, did you know October 5th was Wrongful Conviction Day? Neither did I. But for some reason, I found out about it. Wrongful Conviction Day was an event celebrated around the country to highlight the plight of persons who have been convicted of crimes that they did not convict. Now, obviously, nobody should want anyone who didn't commit the crime to go to jail for a crime they didn't commit. That goes completely against everything that we stand for. And obviously, you would have to be an ostrich with your head in the sand to think that people have not been wrongfully convicted in our judicial process. Now, I will tell you, I believe, and I'm not saying something I am coming up originally by myself. There's a quote that says the American judicial system is absolutely terrible, but it's better than anywhere else in the world. And I truly believe that. If you studied other legal systems throughout the world, I will take the American judicial system here. Is our system perfect? No, it's flawed. Why? We have humans involved. It's going to be flawed. Are mistakes going to be made? Yes, but we do have the appellate process. We have post-conviction matter that can hopefully correct those types of issues. But let's face it, we don't always get it right. And you hear these cases where people spend 20, 30, 40 years behind bars for crimes they didn't commit. How do you compensate those people for that? Well, one thing you need to do is take a look at it. How in the heck did it happen? So the people that have in fact been exonerated, okay, that have been found not guilty, usually through DNA type of evidence, what are the factors that did? First, 58% of all wrongful conviction cases involve perjured or false accusations, and people getting up and basically lying, snitches kind of thing. 54% of the cases usually have some sort of official misconduct by the prosecution or law enforcement. 28% of people who've been wrongfully accused have been identification issues, okay? Identification is so key in any case. Like we've talked about, the elements of any case, they have to say that person did it. Not someone that looked like them, not someone that kind of looked like them. They have to be certain it's him, okay? Identification is such a thing that there's been so many studies on it that people don't focus on a face. If somebody points a gun at your face, you're not looking at the face of somebody, you're looking at the weapon. It's called gun focus. If you're not paying attention directly to the person, you're not going to get a good look at them. Eyewitness identification is flawed, but it's the best we have sometimes. But anyway, 28% of that. False or misleading forensic evidence. 23% of the cases involving wrongful convictions have some sort of false or misleading forensic evidence. We have to be so careful when it comes to these new technologies that we have. And frankly, we have to be concerned about the ones that we use. Remember, all the hair and fiber stuff that we used to use and saying, oh, we think they matched. Even fingerprints are suspect. It's so subjective these days. And of course, a false confession. And you may say, how can anybody falsely confess to something they didn't do? It happens. It happens all the time. People think, I'll tell them what they want to hear just so I can get out of here, thinking it's no big deal. They're not in any trouble. Happens all the time. So think about it. Put it on your calendar for next year, Wrongful Conviction Day. The next case on the docket is not necessarily a criminal case, but it has some roots going back to the common law and criminal law in that regard. A woman's paramour, her boyfriend, has been ordered to pay $750,000 in damages to her ex-husband. In North Carolina, a judge decided that Greg Jernigan must pay Robert Kevin Howard for sleeping with his wife. And apparently, unbeknownst to me, that North Carolina is in fact one of 7 states that still have laws that allow for a scorned spouse to sue their partner's lover. These are called heart bomb torts, which allow for legal actions to be taken against missed affections. That's the term that they use in North Carolina. The term heart bomb or homewrecker laws date back to the 18th century and allow for someone to sue for damage incurred when a third party breaks up a happy home. Alienation of affection, also known as the mother-in-law tort, doesn't have anything to do with sex, but under North Carolina law, one could sue their mother-in-law if the mother-in-law was successful in persuading her child to divorce their spouse. There's also something called criminal conversations in the act of having sex with someone's spouse. The adultery law has an odd name because Old English common law basically stated that it was impolite to talk about sex in the open. They would say that there were impolite conversations was another way to say that they were having sex. So in this particular case, Mr. Howard's wife had met and hung out with Mr. Jernigan, and ultimately they had a sexual relationship which resulted in the destruction of their 12-year-old marriage where they had 2 children. Mr. Howard brought the suit basically to show that there are consequences to these particular matters and that it really does affect people. The $750,000 judgment is basically a lien that they can put on Mr. Jernigan's property. So if he ever sells it, he'll have to pay that award. He'll have to pay that judgment off to get it off the books. Not really criminal law, but kind of way back when. I just thought it was interesting. Most states, adultery is no longer illegal. Most states don't have these heart bomb statutes on the book allowing you to sue. And third, the only place that I can still recall where adultery is still a prosecutable crime is in the United States military. It used to be prosecuted with some regularity, and it usually was only prosecuted when it affected somebody in the command. If a senior officer or a senior enlisted personnel was in fact sleeping with somebody's other spouse in the chain of command, it would affect the good order and discipline, so they had to do it. Not aware of any modern-day adultery cases being prosecuted. And finally on the docket, as we stated, Allison Todd, 45, is never going to get the Mother of the Year award or the month or even of the day award. But she has catapulted herself to the top of the Dumb Criminal of the Week, and it is only Monday. She is the hands-down winner. So what did Miss Todd do that was so heinous? Well, let's say she was charged last year for selling her then 1-year-old daughter for a 1992 Plymouth Laser. Okay, a 27-year-old car for a 1-year-old child. Really? Have you ever seen a 1992 Plymouth Laser? Not exactly the most reliable car I could imagine, let alone giving up your child for a car. This woman will never have this child back. The child is now in the care and custody of the Protective Service. And also, Tina Chavez, 47, and her husband, Vicenio Romero, 53, are never going to have this child because they took the child to the hospital, which presented with bruises on the child as a result of child abuse. And when their story didn't match up as to being the biological or adopted parents, the police and now social services are involved. Miss Todd remains in custody on a $50,000 bond. I wonder why she couldn't use that 1992 Plymouth Laser as collateral on the bond. Anyway, she has court on October 21st. We're going to follow this one because sometimes even a defense attorney can be offended as a member of the community of what people can do. Thank you for watching Crime Talk. That's all we have for you today. Once again, if you like the channel, please subscribe. Please hit that little bell to receive notifications of when we go live. And please leave a comment. We do appreciate what you have to say. We read them. I can't say that I'm going to respond to every one of them, but I certainly do try. I hope you liked the interview that we did with author Cheryl Lynn Cagle, who had written her book regarding the letters from Chris Watts. Now, that hit bright and early on Monday morning, but if you are a Patreon member, you could have had advance access to that. So that's one of the benefits of being a Patreon is sometimes they're going to have events and information that comes out early. And if you were a Patreon, you could have seen it first. So we appreciate for all the Patreons that do contribute. If you'd like to, hit the link below and please join. Have a great day.